Welcome to this episode of Divorce Explained. I'm Steve Benmor, and I'm here with my colleague, Leanne Townsend. And today we are going to be discussing the question that we are often asked, which is, can a judge actually evict one spouse from the home when they break up? That's a common question. Now, let's back up a second and talk about how, first of all, we're not actually giving legal advice right now. We're going to just discuss the law because this is a common topic in the law. And the second thing I want to say is that the answers are very fact specific, as you will see as I walk you through what the law in Ontario is. So for one, when two people own a home together, in other words, they're both on title, then it's not family law per se that controls their rights because they're both the owners of the home. It's real estate law. But this is where things get funny, because if they are common law, i.e. not married, then family law is not the law that controls the right of occupation, the right to evict the other person from the home. It would be real estate law or other form of civil law. But where the spouses are married, that home, whether they rent it, own it, or just occupying it at will, that home is a matrimonial home. It's a defined word, and you could, in fact, look it up by Googling Family Law Act Ontario and reading the definition of what is a matrimonial home, which basically says the home that the couple lived in around the time when they split up. And if they are married, and if this is the home, whether they own it or rent it, then they have the right to come in front of a judge on an application and ask for the eviction of the other person. And in some cases, each is asking for the other one to be evicted. And that language for that is found in the Family Law Act, and specifically Section 24 of the Family Law Act has a whole lovely section called Order for Possession of the Matrimonial Home. And if you scroll all the way through it, it looks into very unique factors like what's in the children's best interest, what's the situation regarding support, what is each side's financial position, was there a prior written agreement, was there any family violence? And the one that I find the most fought over is whether the other person has alternative accommodations, because I could tell you, I've heard some really interesting stories there, like he could move in with his parents, he could move in with his girlfriend, he could stay with my parents, which is always very strange, or he could go to the condo that we own as a rental property or the cottage that we own. So those are the parts of the test that I wanted to lay out for you. But the reality is there's some really good reasons why people really should physically separate around the time that they're splitting up.
Yeah, it's an issue that comes up a lot because let's be honest, people are separating, they're splitting up for a reason. There's problems in the marriage. They don't want to stay together. So usually the two parties don't enjoy living with each other. And that's one of the reasons why they're getting a separation or a divorce. And so you have that situation to start. Then you have the whole family law process. Once the parties retain their lawyers and they start to go through the family law process, even if they're mediating, even if they're not involved in litigation, things usually become more heated between the parties because they're actually having to address the legal issues, the parenting issues, the financial issues. And, inevitably, those are stressful things for people to have to negotiate and go through. And they might not like what the other party's saying. They might not like what the law says about their particular situation. So it's taking a situation that already isn't ideal to people who don't want to be together. You're putting both of them under enormous stress and enormous challenges of the separation process and divorce. And then they're in this home together, living together while they're having to go through these issues. And so inevitably, a client will come to us and say, you know, look, like this situation is toxic. What can we do about it? I want him out of the house. I want her out of the house. Can we get them out? And so that's where we have to look at what the law says, as Steve just described it, and see whether it is a situation where there might be some basis to go to court. Well, first of all, to try and negotiate it. You could, you know, sometimes maybe you're able to negotiate a situation where one party agrees to leave voluntarily. And often in that type of situation, you might have to come to an interim agreement on parenting so that that person knows that they're still going to be getting the amount of parenting time
and paying the bills.
Exactly. All of those things, they need to be sorted out. And so sometimes you can negotiate that and one party will leave. But very often you can't get those things agreed to early on. And so neither party is willing to voluntarily leave the home. And in that case, you have to go to court and you have to bring a motion for exclusive possession. And you're going to have to set out evidence as to why it's going to be in the best interest of the children and why that one party should be forced to leave the home. And judges are very reluctant to make somebody leave the home that they are living in. Both parties have a right to possession of the matrimonial home under the Family Law Act. And to displace that right, a court has to have a party meet a very high threshold. And so it's not something that's just routinely done because there's some fighting going on between the parties. It has to definitely be something more than that.
And that's where the judges really take a holistic approach. They look at all those factors, and good on the Ontario government for creating legislation that lists all of those factors, because it helps us lawyers turn to clients who are asking for us to force their spouse out of the home to look at the list and say, why don't you look at this list and let us know what is it that you say would be a check mark that we would therefore use in order to seek such an order. And I just want to point out that that's the civil route. We see oftentimes this eviction occur as a result of the percolating of tension and strife in the home, which then results in, quite frankly, what would normally occur in a home where there's such tremendous stress: arguments. They argue, they fight, they yell, they scream. And in some cases, that yelling, that screaming might involve something like, I wish you were dead. And then that results in a 911 call, which then results in the police removing the person that said, I wish you were dead, because that might be considered a death threat. And a death threat under the criminal code is an offense. And as a result, the police don't want to take any chances and allow a homicide to occur. So they'll remove the person and then release them on bail terms, provided that they don't come back home. And that takes a life of its own for the next year or two. So there are situations that the criminal side comes before the civil side by virtue of what I just described. And then there are cases where the spouse comes to us and says, I don't want that to happen. I want her or him out of the home so that there isn't arguments and tension and the possibility of words or things being hurled at one another that would make things even worse. But like you said, Leanne, some judges are reluctant to dispossess one spouse. And so when a spouse comes before the court and says, I want her out or I want him out, a proposal that includes all of the other factors makes it sweeter. For example, if they leave, the children can be with him or her on a such and such schedule so that there would be very little disruption to the parent-child bond. If he or she were to leave, the bills would be paid this, that, or the other way. If he or she were to leave, this is what we would do with respect to the home. We would hire an agent. We would try to have it sold as quickly as possible so we could both access our money, so we could both set up new homes in the future. Now, if it's a rental, then it's a lot easier of an argument, because they would just say, I'll pay all the rent, and he or she who's dispossessed can get their own apartment. So you got to build a very compelling case. And the beginning of that is each person provides the storyline stemming from the law that is set out in the Family Law Act.
And it's important for people to understand that title to the home does not govern somebody's right to possession. So you could have a situation where you have a couple that's married and title to the home is, say, in the husband's name only, but it is a matrimonial home. And he may say, well, I own the home. I have title to the home. Why can I not just get her out right now, right away, early on in the separation process? And it just doesn't work that way, because both parties, whether they're on title or not, do have this right to possession of the matrimonial home under the Family Law Act. So title, it doesn't matter for possession purposes. And sometimes a lot of clients have difficulty with that, because they think that because they're the one who is on title, they should be able to dictate who gets to stay there.
And interestingly, there's law, and then there's morality. And at the end of the day, if a relationship is that bad and they really are having a hard time, and the children are seeing that they're really having a hard time, it really should never get to the point of bringing an application in front of a judge to evict. This is back to where we go with getting good legal advice, being able to negotiate and or mediate even a temporary arrangement. By way of an example, I've had clients who have said, I'm not moving out, because if I move out, I lose my rights to the kid, I lose my rights to the house. Okay, valid point. Maybe they do, maybe they don't, I don't know. But I say, why don't we do a 3-month without prejudice agreement where you move out, and these are the conditions. And if at the end of the 3 months, we are unable to either cause you and your wife or you and your husband to reconcile, you could move back in, or you could mediate a resolution over the next 30, 60, 90 days before moving in, or the very issues surrounding who stays in the home and what the relationship will be with the children and who pays the bills will be decided by such and such arbitrator within 45 days, something along those lines. Now we are protecting the person against the thing that they feared, which is losing the children, losing the house. We've covered that. And at the same time, we've reduced the tension and the temperature in the home that will allow for a more sober and calm approach to how to resolve the real pressing issues of how to recreate this family's life now that they're no longer together.
And that approach is so important, because if the person who is maybe agreeable to moving out of the home knows that their rights are not going to be negatively affected, they may be much more apt to do it. And I think that there's this it's not a myth, because your rights are affected, but a lot of people, the first thing their friends and family will always tell them when they're getting separated is, don't move out of the matrimonial home. You got to stay there. And I always remember, and I'm aging myself here, but a movie when I was growing up called The War of the Roses. It was with Michael Douglas and Kathleen Turner. And this couple was going through just a bitter, high conflict divorce. And neither one of them would leave that matrimonial home. And they ended up destroying the home in their aggression and anger towards one another. They were actually physically destroying the home. And, it can go much, and destroying their own lives, their own mental health. And that's where I was going to take this, is that staying in a home with someone when it's a toxic environment for everybody, and most especially your children, that is not that's not good parenting. That's not doing a good thing. And so, as I would always say to anyone going through separation and divorce, you should always be putting the best interests of your children first. And if you're feeling the toxicity of the environment, imagine how your children are feeling, and it's okay to be the bigger person and say, you know what, I am prepared to move out. But before you do, make sure that you do get some sort of agreement in place so that you know that your rights are protected, because you don't want that decision of and having been the bigger person in the situation, you don't want that coming back to bite you and affecting you negatively with respect to your other rights.
Absolutely. And I'll tell you, the agreement that you could reach with your spouse before you leave may not be an agreement to a parenting schedule with the kids or to the sale of the home or even to any of the financial issues. It could actually just be an agreement to disagree and an agreement to take the disagreement to a mediator arbitrator who will speedily resolve these issues within days, weeks, and months, as opposed to what you see in the tagline here, can a judge evict? Because let's be frank, for you to get a judge to evict, you're starting a court case. And if you're starting a court case, you're spending tens of thousands of dollars and waiting anywhere from 3 to 12 months for the judge to do this thing called an eviction. All of that could have been resolved much faster, cheaper, and easier with a mediator arbitrator.
Absolutely. So thank you everyone for joining us today. Thank you, Steve. And we will see you here again next time on Divorce